5 seconds to go. Start. During the settlement proceedings, SEBI had appointed Shri Y.H. Malegam, Chartered Accountant on the advice of Justice Retired B.N. Shri Krishna. Accordingly, the Chartered Accountant is supposed to have submitted a report to SEBI. During the settlement proceedings, the appellant submitted an application dated 21st January 2019, wherein it sought the aforesaid documents. In response, SEBI, wide letter dated 28th January 2019, rejected the request by relying on the provisions of Section 13(2) of the Securities and Exchange Board of India Settlement Proceedings Regulations, 2018, hereinafter Settlement Regulations. Para. The aforesaid letter dated 28th January 2019, was impugned by the appellant before the High Court of Judicature at Bombay in WP number 300 of 2019. The High Court, by final order dated 4th February 2019, while dismissing the aforesaid writ petition, held as under, para. The internal committee of the SEBI is seized of the matter. During the proceedings, an application came to be filed by the petitioner seeking copies of certain documents, including copy of the report submitted by Mr. Malegam. The provisions of Regulation 13(2)A are clear. These regulations do not confer any right on the petitioner to ask for a copy of the said report. In that view of the matter, the issue of principles of fairness does not arise at this stage, considering the purpose of the proceedings before the internal committee and powers of the high power committee and the regulations framed in this regard. There is no right conferred under the regulations on the petitioner to ask for such a copy. In the facts, we are not convinced to exercise our writ jurisdiction. Para. As and when the adjudicatory proceedings takes place, the petitioner may ask for copies of such documents in accordance with the procedure established to conduct the proceedings. Para. We may only note that the High Court was dealing with specific requests that were made during the settlement proceedings under Regulation 13(2) of the Settlement Regulations. From a reading of the explanation appended to Regulation 13(2)A of the Settlement Regulations, it is clear that the intention of settlement proceedings is to facilitate the regulator to consider the feasibility of settlement in certain cases, without allowing a roving and fishing expedition. However, the findings of the High Court in the aforesaid case are of no avail to the SEBI, as we are at a stage when SEBI has invoked the provisions under the criminal law to prosecute the appellant herein. Para. At this juncture, SEBI relies on Regulation 29 of Securities and Exchange Board of India Settlement Proceedings Regulations 2018, which notes as under, para. All information submitted and discussions held in pursuance of the settlement proceedings under these regulations shall be deemed to have been received or made in a fiduciary capacity, and the same may not be released to the public. If the same prejudices the board and or the appellant. Para. Where an application is rejected or withdrawn, the applicant and the board shall not rely upon or introduce as evidence before any court or tribunal, any proposals made or information submitted or representation made by the applicant under these regulations.